Have you ever read something, maybe a law, maybe a contract, or heck, even just assembly instructions, and thought, yeah, that seems perfectly clear. And then like a second later, you kind of tilt your head and go, wait, or it could mean that.
Happens all the time.
Well, you're definitely not alone. It turns out the actual words used in statutes, deeds, all sorts of documents, they can often be ambiguous. They can lead to different interpretations and sometimes pretty big arguments.
Absolutely.
And that's the really fascinating challenge we're diving into today. Our mission for this deep dive is to unpack this crucial, maybe sometimes hidden skill of interpretation, not just in, high court legal battles, but really in any situation where we need to truly understand written words.
Right.
We're drawing on insights from a really thorough exploration of interpretation of statutes, deeds, and documents, which, okay, sounds maybe a bit dense.
It can sound that way initially, yeah.
But as we'll find out, it has these huge implications for how justice actually works and, honestly, how we navigate almost every written agreement in our lives.
That's a great way to put it. At its core, interpretation is really the process courts use, or frankly anyone uses, when they're trying to understand a rule or agreement to figure out the real meaning, the intent behind the words on the page.
So it's like a bridge.
Exactly. It's the bridge between what the writer, the framer of the law actually wrote down and how it gets applied in the real world. And it becomes absolutely critical when a word or phrase could, reasonably mean more than one thing.
Okay, let's unpack this a bit. Why do we even need interpretation? I mean, don't the people writing laws, don't legislators just try to write them clearly? Why isn't it just straightforward?
Well, you'd hope so, wouldn't you? And they certainly try. But it's rarely that simple. There are some inherent challenges. First off, ambiguity. Laws can just be vague or use words that naturally have several meanings. Think about the word reasonable. What does that actually mean?
Right, depends.
Exactly. Second, you have unforeseen situations. Drafters, no matter how smart, just can't predict every single future eventuality. New tech comes along, society changes.
And suddenly an old law has to apply to something totally new.
Precisely. And maybe the biggest reason is that language itself. It's just not math, it's flexible. There's a great quote from Lord Denning, a famous English judge. He said, "The English language is not an instrument of mathematical precision. Our literature would be much the poorer if it were."
I like that.
Yeah. So judges aren't just reading words on a page. They're trying to figure out the intention of Parliament or whoever wrote the document. They have to consider not just the language, but also, the social conditions at the time and the specific problem, the mischief the law was trying to fix.
Okay, that puts it in a different light. So this isn't just about, dusty old law books and technicalities.
It's not at all.
It's really about making sure laws and agreements actually work for people. For society, not just getting stuck on the literal words if they don't make sense in context.
That's the goal, yes.
So before we get into the how of interpretation, could you quickly define a few key terms we'll probably be throwing around?
Sure, happy to. Let's start with statute. That's simply a law passed by a legislative body, parliament, a state legislature. Think acts of parliament. It's the formal written law.
Yeah, statute, got it.
Then there's document. This is broader. It's basically any matter expressed or described on some substance, paper, film, whatever, using letters, figures, marks, essentially for the purpose of recording that matter. So a writing, sure, but also a photograph, even a map or a plan. It needs 4 things: the matter itself, the record, the substance it's on, and the means used to record it.
Right. Much broader than just words.
Definitely. An instrument is a bit more specific again. It's a formal legal document and usually creates or confirms a right or maybe records a fact. Think of an agreement, a contract, a will.
Okay, formal legal doc.
And finally, a deed. This is a specific type of instrument, usually in writing, and its main job is to effect some kind of legal disposition, transferring property, creating an obligation. Think of the deed to your house.
Okay, so all deeds are instruments.
But not all instruments are deeds. Exactly. Though sometimes in practice, especially here in India, the terms get used a bit interchangeably.
Good distinction. And you also mentioned interpretation versus construction. Are they different?
Technically, yes, though they're often used together. Think of interpretation as figuring out the meaning of the words themselves. What did the author actually say? Construction is maybe a step further, drawing conclusions about the spirit or the overall intention, sometimes going beyond the direct expression of the words.
So like letter versus spirit?
Kind of, yeah. But in practice, judges and lawyers often use construction to include interpretation. For our chat today, we'll mostly use them synonymously. The main point is getting to the intended meaning, not just the surface words.
Okay, that helps clear things up. So now we know why we need to interpret. Let's get into the how. Our source material mentions these primary rules that courts use as guides. Where do they start? What's rule number 1?
Well, the first stop is usually the rule of literal construction. It sounds just like what it is.
Read the words.
Exactly. If the words of the statute or document are plain, simple, unambiguous, you just give them their ordinary, natural grammatical meaning. The idea is, as the Latin maxim goes, absoluta sententia expositore non indigit. Plain words need no explanation.
If it ain't broke, don't fix it.
Pretty much. There was a classic case in India involving sales tax on betel leaves. The question was, should betel leaves be defined botanically, technically, or just how people normally talk about them?
Like in the market.
Right. The Supreme Court said, you use the popular meaning, the common understanding in trade. That's how the law intended it. Now, if a word is genuinely technical, say in an engineering spec, then yes, you'd give it its technical meaning. That came up in another case, Ashwini Kumar Ghose v. Arabinda Bose.
Makes sense. Use the normal meaning unless it's clearly a technical term.
But, and this is important, there's a nuance. Even with the literal rule, sometimes sticking too rigidly to the dictionary definition would actually defeat the whole purpose of the law. Well, take the Companies Act, Section 102. It talks about disclosing the nature of concern or interest, financial or otherwise. If you read otherwise really, really narrowly, you might miss important non-financial conflicts of interest.
Right, like a personal connection or something.
Exactly. So the courts have said, in a case like that, you need a wider interpretation to achieve the law's clear goal, which is full and frank disclosure to shareholders. The literal meaning is the starting point, but it has to serve the law's purpose.
Okay, so the words are primary, but purpose matters too. That seems to lead nicely into what's often called the golden rule or the rule of reasonable construction. I guess this kicks in when the literal reading just doesn't work.
Precisely. This is where it gets quite interesting. When a literal interpretation leads to a result that's manifestly absurd or maybe illogical, or it just completely undermines what the law was trying to achieve.
Like your example of no vehicles in the park, including a kid's toy car.
Exactly like that. The court can then step back and adopt a more logical interpretation. There's another Latin maxim for this. Interpretatio fienda es ut res magis valeat quam pereat. Basically, construe the words so the law makes sense and works, rather than making it futile or silly.
So if the literal reading sounds utterly ridiculous, the court can basically say, hang on, that can't possibly be what they meant.
That's the essence of it. It's a safety valve against absurdity.
Okay, that makes a lot of sense, but here's where it gets really interesting for me. What happens when different bits of the same law seem to say opposite things? Like one section contradicts another.
Yes, internal conflicts. That's a classic interpretation puzzle. And that's where the rule of harmonious construction comes into play.
Harmonious. Like make them sing together.
Kind of, yeah. The goal is to read the statute, the whole act, as one coherent piece. You try your best to interpret the different provisions so that they all make sense and can work together effectively. You want to avoid a situation where one part cancels out another part.
So you try to make them fit?
You absolutely try. Now, if after trying really hard, you find there's an irreconcilable conflict, then another principle often comes in. Generalia specialibus non derogant.
Latin again.
It just means general things don't override specific things. So if you have a specific rule about, say, issuing shares to employees and a very general rule about issuing shares overall, and they conflict in some way you can't harmonize, the specific rule about employee shares will usually prevail for that situation.
Okay, specific trumps general if you can't make them work together.
Correct. And laws also use specific little phrases, kind of like signposts, to tell you how different clauses relate. If a section says it's subject to another section.
It means the other section is boss.
Essentially, yes. The first section has to operate within the limits set by the second one. For instance, the Companies Act says changing a company's name under Section 13.2 is subject to the rules about name availability in Section 4.
Got it. What about notwithstanding? I see that one a lot.
Notwithstanding is powerful. It basically means, despite what other sections might say, this rule prevails. It overrides conflicting provisions. Section 4211 of the Companies Act, for example, says if you mess up a private placement, it's deemed a public offer, notwithstanding anything in the earlier subsections about private placements.
Sounds like a trump card.
It really is. And then there's without prejudice. This means a particular provision operates in addition to and doesn't harm or take away from other general provisions. They both apply. Section 4.3, on name registration, for instance, operates without prejudice to the general naming rules in Section 4.2.
Wow, those little words pack a punch. It's like a hidden code in the text.
It really is. They guide the reader on how the pieces fit together.
Okay, moving on. Sometimes it feels like to really get a law, you have to put on a detective hat and figure out what problem it was trying to solve in the first place. That's the mischief rule, right? Comes from an old case, Hayden's case.
That's the one. And it's particularly useful when the language itself is genuinely ambiguous or unclear. The mischief rule asks the court to consider 4 specific things.
Okay, lay them out for us.
1. What was the common law, the legal situation, before this act was passed? 2. What was the specific problem, the defect, the mischief that the old law didn't adequately deal with?
Right, what was broken?
Exactly. 3. What remedy, what solution did Parliament provide in this new act to fix that mischief? And 4. What were the true reasons behind providing that remedy? The whole point is to interpret the act in a way that helps suppress the mischief and advance the remedy.
So figure out the problem and make sure the solution actually works.
That's the core idea. There's a good example with the Prize Competition Act of 1955 in India. The question was, did this act regulate all competitions with prizes or only those that were essentially gambling?
Because some competitions are skill-based, right? Like
Yeah.
a crossword puzzle prize.
Precisely. The court used the mischief rule. They looked back and saw the mischief the act was targeting was the spread of unregulated gambling disguised as competitions. So they interpreted the act to apply only to competitions that were gambling in nature, where chance dominated over skill. It suppressed the gambling mischief without harming legitimate skill contests.
That's a really clear example of getting to the spirit of the law, not just the literal words.
Yeah.
Okay, let's zoom in a bit now. You mentioned earlier how even common words can trip us up in legal texts, like
Yeah.
and isn't always and,
Yeah.
and may isn't always just a suggestion.
That's absolutely right. This is where interpretation gets really granular and honestly quite fascinating. Common words can behave differently in legal language. Take and or. Normally, and joins things, A and B must both be true, and or separates them, either A or B.
Standard grammar.
Right. But in law, if the clear intention of the legislature or the document requires it, courts can sometimes read and as if it were or, and vice versa. There are cases like Municipal Council v. Bishandas Nasmal where this happened to make sense of the provision. It's about achieving the intended outcome.
So context and intent can literally flip the meaning of and or.
Wow. It shows how focused interpretation is on purpose, not just grammar rules in isolation. And it's even more complex with words like may, must, and shall.
Yeah, we all learn those basic meanings in school, but you're saying in law, it's fuzzier.
It can be. Whether a legal provision is mandatory, you must do it, or just directory, you should do it, but it's not fatal if you don't, depends fundamentally on the legislature's intent, not just on whether they used shall or may.
So shall doesn't always mean absolutely must.
Not always. Sometimes, looking at the context, the purpose of the rule, and the consequences of not following it, a court might decide that shall was actually intended to be directory, meaning permissive. And conversely, may, which sounds optional, can sometimes impose a duty.
How can may impose a duty?
Well, think about it this way. Sometimes a law gives a public official the power to do something. The official may issue a license if certain conditions are met. If those conditions are met and the purpose of the law is, say, public safety, then that power effectively becomes a duty. The official must issue the license. Lord Justice Cotton said something like, may can give a power that creates a duty to exercise it.
Okay, so the label isn't the whole story. You have to look at the function, the purpose.
Always the purpose.
Right, let's tackle another one of those Latin phrases. E justum generis. You mentioned it means of the same kind or species. It sounds like it's about lists.
It is, specifically about lists. The rule of ejusdem generis comes into play when you have a list of specific words belonging to a clear category or class, followed by general words.
Like dogs, cats, hamsters, and other animals.
Perfect example. The general words other animals are then restricted in meaning. They're generally interpreted to include only other animals of the same kind as those specifically listed. So, in your example, it would probably mean other domestic pets, not, say, lions or eagles.
Okay, so it limits the general term based on the specific examples before it.
Exactly. It prevents the general words from having an unintentionally wide scope. For this rule to apply, there are usually about 5 conditions. There has to be an enumeration of specific things. They have to form a distinct class. That class shouldn't be exhausted by the specifics. The general words must follow the specifics, and there shouldn't be any clear legislative intent against applying the rule.
Got it. So it helps keep things focused when you have a list ending with something broad like "and others."
Precisely.
Okay, so we've got these primary rules. But beyond those, what other tools or clues do judges and lawyers use to figure out what a law or document really means? Surely it's not just the main text.
You're right, it's not. There are what we call internal aids and external aids to interpretation. Internal aids are clues found within the statute or document itself, outside the main operative sections.
Like what kind of clues?
Well, think about the long title and the preamble of an act. The long title usually sets out the general purpose, and the preamble often explains the reasons for the act and its objectives. They're like the mission statement.
So they give you the big picture.
Exactly. While they can't override clear, unambiguous language in the main sections if there is ambiguity, the long title and preamble are really valuable guides to the intended scope and purpose. We mentioned the Hindu Marriage Act earlier. The preamble stating its purpose was to codify Hindu marriage law helped interpret may as mandatory.
Okay, so title and intro matter. What else?
Headings given to different parts or sections of an act can be useful guides to the subject matter covered. Marginal notes, those little notes sometimes printed beside sections, are generally not considered a reliable aid in most systems, often because they might be added later by clerks, not by the legislature itself. Although there can be exceptions, like notes accompanying articles in the Constitution of India.
Interesting distinction. How about definitions? Lots of acts have definition sections.
Absolutely crucial. Definitional sections or interpretation clauses are where the legislature tells you exactly what certain words mean for the purposes of that act, and the wording here is key. If a definition says a term means X, Y, and Z, that's generally restrictive or exhaustive. That's all it means in that act.
Closed list.
Right. If it says a term includes X, Y, and Z, that's usually extensive. It means it covers X, Y, and Z, but might cover other things too.
Open list.
Exactly. And if it says means and includes, it's usually treated as exhaustive, defining the term completely. A phrase like deemed to include creates a legal fiction. It tells you to treat something as included, even if it wouldn't normally be. And importantly, once a term is defined, that definition generally applies every time that word appears throughout the entire act, unless the context clearly demands otherwise.
That consistency seems vital.
It is. Then you also have things like illustrations examples provided within the act to clarify a section. They help explain but don't change the law itself. Provisos clauses, usually starting with provided that, which carve out exceptions or qualifications to the main rule just stated. Explanations, which are added to clarify ambiguity or provide further meaning. And schedules, often found at the end, which contain detailed lists, forms, or technical rules related to the main sections.
Wow, okay. So it really is like reading a complex book. You can't just read the main chapters. You need the title, the intro, the glossary, the footnotes, the appendix. All of it contributes to the full picture.
That's a perfect analogy, and it underscores the most fundamental principle of all. Read the statute as a whole. You can't just isolate one section or one sentence. How a word is used in one part sheds light on its meaning in another. We had an example earlier about notice. If one section just says notice, but another specifies it must be served or left, that tells you it probably means written notice throughout. Context is everything.
Makes total sense. Okay, those are the clues inside the document. What about external aids? Things from outside the text.
Right. When the language of the statute itself remains ambiguous, even after looking at all the internal aids, courts can look outside the act for help. One key external aid is the historical setting. Understanding the circumstances, the societal problems, the debates that led to the law being passed can illuminate its purpose.
Like the mischief rule, but broader history.
Sort of, yes. Understanding the context in which it was born. Another is usage, sometimes called contemporanea expositio. How was the law understood and applied by officials and the public at the time it was enacted or shortly after? This is particularly relevant for very old statutes, the idea being that the best interpretation is the one given contemporaneously.
How people used it back then.
Exactly. Courts also look at earlier and later acts on the same subject and analogous acts. Laws dealing with the same subject matter, what lawyers call laws in pari materia, are often read together to ensure consistency.
Okay. What about just looking it up in the dictionary?
Dictionary definitions can be useful, certainly, especially if a word isn't defined in the act itself, but they're just a starting point. The legal context, the purpose of the statute, always takes precedence. And judicial decisions interpreting the same word in similar laws often carry more weight than a general dictionary definition.
Right, context is king.
Always. And finally, sometimes courts look at foreign decisions, like rulings from the UK, US, or other common law countries, especially if their laws are similar. But this is purely persuasive. The language and context of the specific Indian statute being interpreted remain the primary focus.
Okay, that's a really comprehensive toolkit. So we've spent a lot of time on statutes, on laws passed by Parliament, but what about all those other legal documents that, we might actually sign or deal with more often? Contracts, agreements, wills, maybe even just the terms and conditions we click agree to online.
That's a crucial connection to make because the good news is the fundamental principles for interpreting deeds and documents are very, very similar to those for statutes.
Really, the same basic ideas apply.
Largely, yes. The ultimate golden rule is still to figure out the intention of the parties who created that document. And you do that primarily by looking at the words they used, giving them their ordinary, natural meaning in the context of the whole document.
So what would a normal person think this means?
Exactly. Courts often apply a reasonable person standard. What would a reasonable person, knowing the relevant background facts, understand these words to mean? If you're looking at, say, a lease agreement, how would a typical informed tenant and landlord understand that clause?
Okay, that makes sense. Are there any specific twists for documents compared to statutes?
A few nuances, yes. For instance, the status and training of the parties involved can sometimes matter. A word used in a complex commercial contract drafted by teams of lawyers might be given a more precise technical meaning than the exact same word used in a simple agreement handwritten between two neighbors.
Ah, okay, the context of who wrote it.
Right. Also, the principle of consistency, same word, same meaning, generally applies strongly within a single document. If delivery means one thing in Clause 3 of a contract, it's presumed to mean the same thing in Clause 10 unless the context absolutely forces a different reading.
Keep it consistent.
Definitely. And one interesting point of difference sometimes arises with conflicting clauses. We said with statutes, you try to harmonize, and if not, specific might trump general. With deeds and documents, especially older ones, if there's a truly irreconcilable conflict between two clauses, there's a traditional rule that the earlier clause in the document prevails over the later one.
The first one wins. Why is that?
The thinking historically was that the first clause represents the primary intention, and the later conflicting one might have been an error or afterthought. It's not an absolute rule, and harmonization is always preferred, but it's a principle sometimes applied in document interpretation that you don't see as much with the statutes. It really makes you think about clarity when you're drafting anything important.
Absolutely. Wow. What a journey we've been on from just realizing that legal language isn't always clear.
Which is a big first step.
All the way through these different rules, the internal clues, the external factors that legal minds use to try and figure out the true meaning, the real intent behind the words. It really shows that law isn't just some static set of commands. It's this dynamic process of understanding language.
It really does, and it highlights just how vital these interpretation skills are, not just for lawyers and judges, obviously, but really for anyone trying to navigate the modern world. Think about policies, regulations, contracts, terms of service. They're everywhere.
Yeah.
And it's worth remembering, courts actively try not to interpret a law or a document in a way that makes it pointless or ineffective. They lean towards interpretations that make the thing work, that give it teeth, that make it operative. They assume the writers intended it to have a real effect.
So what does this all mean for you listening right now?
Right.
Well, the next time you're reading a contract, maybe some new legislation that affects your work, or even just those complicated instructions for putting something together. Remember that words, well, they're rarely as simple as they first appear. This whole deep dive into interpretation, I think it shows us that real understanding isn't just about reading the black and white text. It's about digging deeper, understanding the intent, seeing the context, and appreciating that subtle, sometimes tricky dance between what's literally said and what's actually meant.
Well put.
And maybe here's a final thought to chew on. How might applying some of these principles, thinking about intent, context, potential ambiguities, this mischief something is trying to fix, how might that change how you approach complex information in your own life? Maybe it's understanding a new policy at work, or deciphering a really dense online user agreement, or even just trying to understand a conversation where you're getting mixed signals. The tools of legal interpretation, surprisingly perhaps, can be really powerful guides for navigating ambiguity just about everywhere.